Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're talking about social media and schools. With back to school in session for the fall, there are some changes. Alberta, British Columbia, Ontario, Quebec, Nova Scotia, and New Brunswick have all restricted phones in the classroom. The move has come as a relief to some parents, but others believe that it may not be enough. A group of Ontario school boards began a legal action last spring against tech giants Meta, which includes Facebook and Instagram, against Snapchat and TikTok for disrupting student learning and the education system. The lawsuit claims that the social media products are negligently designed for compulsive use and have rewired the way children think, behave, and learn. Teachers and the school system are then left to manage the fallout. Collectively, the school boards are claiming more than $4 billion in damage and are calling on the tech giants to redesign their products. I'm joined today by two of the lawyers representing the school boards, Michael Wolkowitz and Sonia Nidger. Mike, Sonia, thank you both so much for joining me today. Mike, how about we start with you? Maybe you can tell me how this case got started.
Yeah, so first of all, thanks for having us, Christine. How the case got started was, as concerned parents, I think we started to look into what effect social media was having on our children and students. And we began to investigate the problem. A lot of this began with the Facebook whistleblower, Frances Haugen, who came forward and brought to the public's attention that the way that the products themselves were designed was done in such a way that it was meant to create compulsive use. And so what effectively the social media companies are doing is they're vying for eyeballs and they're vying for time. And they're using our children as a resource to try to sell advertising space. And they're doing that by employing certain product features that keep people on the platforms for longer. And these product designs are particularly effective with children.
Now, Sonia, maybe you could describe some of the different types of harm that your lawsuit is alleging that these platforms cause.
Yeah, sure. Also, thanks, Christine, for having us. It's a pleasure to be here. So, the harm that we're alleging in this specific lawsuit is certainly specific to what we're saying is a disruption fundamentally to the education system. Now, there is a ton of medical, academic, I'll say anecdotal evidence or consensus on how these products are manifesting and how they are affecting children. But what we're seeing and what we're alleging is that because of what Michael just described in terms of the tactics of these companies, the design features of these companies, which is really meant to prolong use and just have eyeballs on the screen as long as possible, that's fundamentally disrupting brain chemistry. It's fundamentally disrupting the way that the brain is, the young brain especially is developed, and that's having impacts on behavior, social emotional regulation. What we're saying that boils down to in this litigation is the effect on school climate. There is a significant impact on the way that kids are learning. There's a significant impact on the way that schools are operating, frankly, and able to really discharge their fundamental mandate, which is to teach the next generation of leaders. And so the harm is widespread everywhere from, the administration to the classroom. And that is significant. This is a huge problem. We say it's a generational issue.
Mike, maybe you can paint a picture for us. I mean, a lot of our viewers will have kids in school, so they perhaps know what it looks like, but maybe you can describe what classrooms are looking like with the prevalence of phones in classrooms and the habitual use of social media on these phones.
Yeah, so I think, you can start with the premise that teaching is difficult to begin with, right? And what we have now is a fundamentally altered student population. And what we're seeing and what we're hearing from our clients is that it's become harder to educate. And that means less student focus, harder to maintain and create attention, difficulties regulating behavior. What we see or what we hear from our clients is that really manifestations of compulsive use issues. And so students are just not able to learn in the same way that they were in the past. And the schools and the school climate has had to adapt to that. On top of this, we're also seeing issues with how administrators and teachers spend their time, right? There's a lot of time spent having to deal with issues that are manifesting on social media and then are entering the classroom, whether that be social issues or issues, with things like sexual exploitation of minors or poor sleep hygiene, just to name a few things, body dysmorphia issues. So there's a huge rise in these.
We've got to go to break, Mike, but we'll be right back. Welcome back to Canadian Justice, where we're discussing a lawsuit against tech giants for causing disruptions in the classroom learning environment. Now, Mike, one of the things that I discussed with my friends, we all have kids, and I definitely understand the habitual use of phones. I mean, I fall victim to it myself, but I also wonder about the role of parents in this equation. And a lot of friends of mine are starting to say, I'm not giving my teen or my young child a phone because of the challenges that I myself have regulating the time I spend using it. So I'm curious what the reaction to that has been about the role of parental responsibility in this issue.
Yeah, look, it's a good question. I think that there isn't one solution to this problem. I think this problem is so large that to suggest that, we can flip a switch and it'll be solved is unrealistic. But what is important to think about is that we all have a role to play in it, whether it's parents, whether it's government regulation, and whether it's accountability on the part of the social media companies. We see our litigation as one element of that solution. I think that what we've seen since this claim actually began is a huge shift in the way that we as a society think about social media usage. And we see a lot more government regulation and a lot more public support for putting guardrails on social media, especially with children. Just recently, Australia announced that they're going to be implementing a policy that limits or prevents social media use for children under the age of 14 or 16, which they're still determining. And I think you're going to see a lot more action like that. For sure, parents have a role to play in this. I think that one of the things that we have to remember is that we only recently began to understand the way that these products were designed and the way that they hook children and keep them on the platforms. And so, yes, parents for sure have to take some responsibility, but I think the main thrust of the problem is that these products were inherently designed in a way that's meant to manipulate children and to keep them on the platforms for as long as possible.
So now I want to ask about recent developments. And I'm going to turn to you, Sonia, because a number of provinces have actually, since this lawsuit was announced, have now banned phones in classrooms. So what do you think of that move? And does it change anything in the case that you're bringing?
As Michael said, Christine, this is a multifaceted problem and it's going to require a multi-pronged approach. I mean, our litigation, as we say, is one aspect of tackling this enormous issue, but we're going to need more than that. And so we welcome any change, any attention to this issue that results in policy change like the one that you're describing. I think, it's an important issue that has not gotten a lot of airtime for many different reasons, and so for there to be change is inherently a good thing. Does it change anything? Listen, the issues that we've alleged in our statement of claim on behalf of the school boards, they're both very significant, and they also emanate from beyond just the classroom and beyond use in school hours. This is a systemic issue that we say has been, as we've talked about, manipulated by and leveraged by these companies to create a change in the way that kids are behaving, to create a change in the way that the education system can actually operate. So it goes beyond use in the classrooms, but we welcome, all attention to this issue.
Now, Mike, I'm really curious about what the public response to your lawsuit has been. Have you heard back from teachers, educators, parents, students? What has been the response?
Yeah, I think overwhelmingly it's been positive, especially on the part of teachers and educators. I think they're the ones who have been sort of ringing the alarm bell for a while about how serious a problem they're seeing in our classrooms. And I think that they feel supported by this litigation, and they think that, regardless of outcome, it's again drawing attention to something that desperately needs attention drawn to it.
Sonia, anything to add there about the public reaction to the lawsuit and what you've been hearing from parents?
Yeah, I think what we've been hearing is that, finally there's been something done about this enormous issue, that finally we're shedding light on something that has largely been behind closed doors until we've had whistleblowers come out and, do what they've done. And so, this is, again, I'm going to say it again, a generational issue. It is going to require the public to be involved, to, both have opinions and then to
Hmm.
execute on
Hmm.
what the facts are.
We've got to go to commercial break now, but when we come back, I want to talk about some of those whistleblowers from the US that you mentioned in the earlier segment. We'll be right back. Welcome back to Canadian Justice, where we're discussing the lawsuit against social media tech giants for creating classroom distractions. Now, Mike, this is a large claim, $4.5 billion. I imagine there are going to be experts involved to provide evidence. And I know you mentioned, or Sonia mentioned, one of the high profile whistleblowers from the US who testified about social media companies and the way that they're designed. Do you have experts in this case? And what type of experts might we expect? And what type of expert arguments might they be making?
Yeah, so of course, there will be expert evidence forming part of this case. In terms of what areas they'll be asked to comment on, there's many. I suspect it'll be about how the products are designed, what impact they're having on children and all individuals for that matter. What the negative effects have been. So it'll be, comprised of doctors, academics, researchers, scientists, all kinds of different areas. To go back to the whistleblower comment, certainly that's played a big role in what our understanding is about the inner workings of the companies, and certainly it forms a large part of what allegations inform our claim. From things like just what the companies were aware of, and in terms of their own investigations as to what effects their products are having on children and users more generally. That means things such as on their mental and behavioral impairments, and also on screen time and disruption in classrooms and so on and so forth. So that has largely informed, the allegations that form the bedrock of our case.
So Sonia, I'm interested in the companies because as I understand, the claim is against Meta, which is Facebook and Instagram. It's against TikTok and Snapchat. And I'm curious why those platforms and not others like YouTube or WhatsApp or X, which, speaking personally, are the apps that actually drain my time, not Facebook.
Yeah, and Christine, I think you just identified maybe part of the reason. So, our claim is about what's happening in the education system amongst school age children. So, we identified the products and the companies who've achieved significant market penetration amongst that demographic and who endorse the types of what we say are design defects and tactics that we allege that are negligent. And so it really just came down to those three factors.
So this is one of the things that our viewers might be curious about because the claim is in negligence. And I think what some people, when they think of negligence, they might think of an accident. But in this case, it seems like an intentional design that is causing harm. So or that you're alleging is causing harm. So perhaps you could explain to our viewers the concept of negligence and why an intentionally designed product could still be negligent.
Yeah, so first of all, intention doesn't necessarily need to form an element of negligence. So what really negligence is saying is that we as a society are imposing a legal obligation on people to act in a reasonable way. And when we're not acting in a reasonable way and it causes harm to others in our orbit, we need to be held to account. And the way that we hold people to account is through compensation, which we call damages, right? So the key elements of a negligence claim are duty of care. Is there a standard of care? What is the standard of care? Has that standard of care been breached? Have damages been suffered because of it? And did that breach of the standard of care cause those damages? And so what we're saying here is that the products have been designed in a way, or what we're alleging is that the products have been designed in a way that has created damages, and that those damages have resulted in the need for compensation, and they were directly caused by the products.
Sonia, is there anything you wanna add there? I feel like I'm back in law school in torts class, Mike. So thanks for that.
No, I think Mike got it totally right. I mean, we've alleged a number of very specific breaches that we say amount to a breach in the standard of care that these companies have, we say, done, and we look forward to proving those elements through this litigation.
Now we've got to go to commercial break now, but when we come back, I want to ask you about Premier Ford, because Premier Ford has actually commented on your lawsuit. I imagine that's not something that happens every day. So I want to get your reaction to that. He has said that the lawsuit, that we should be focusing on kids and not on lawsuits. So when we come back from the break, I want to get your reaction to that comment from our Premier. We'll be right back. Welcome back to Canadian Justice, where we're discussing the lawsuit against social media giants for causing classroom disruptions. Now, Mike, when this lawsuit was filed, Ontario Premier Doug Ford, he was critical of it. And he said, instead of lawsuits, the focus should be on the kids. So what is your response to that comment from the Premier?
Yeah, so just to call back to something I said earlier, I do think that this is a problem that requires multi-pronged and multifaceted solution. So we think that, again, litigation is just one tool for that solution. In terms of focusing on the children or the students more specifically in our context, the intention of this litigation is the benefit of the students. What we hear from our clients, the school boards, is that they need more resources to focus on better student education and student well-being. And that's what the emphasis of the litigation is. It's to provide those tools and resources. So, if there should be a positive outcome, then that is where the damages will be put towards. It's just creating a better student climate and a better environment for learning.
So, Sonia, I think it's noteworthy that shortly after criticizing the lawsuit, Premier Ford actually announced the policy change that banned phones in classrooms. Something that, I mean, it's crazy to me that they weren't already banned. But do you think that the lawsuit was part of what contributed to that policy change?
What I'd say to that is that we're proud that this litigation has put a spotlight and a microphone on this issue, right? This issue has been kind of in the water. We all know it. Christine, you alluded to, experiencing it yourself. And so we've all kind of as a society accepted that this is happening. And what we're saying in this litigation is let's not accept it. Let's not accept it and let's do something about it. And so we're proud that the litigation is something that we are doing to address this. And we're proud that it spurred change, whatever that change might look like. And we look forward to more change. We look forward to more collaboration. We think, as I mentioned earlier, this is an issue that the public needs to get involved with. They need to have a voice. They need to have an opinion, and we need to move forward. All stakeholders and we're all stakeholders in this, right? We're talking about the future generation of leaders and our future. And so we're proud that it spurred dialogue and change. We think that was sorely needed in Canada, especially, and we look forward to whatever may come in that regard.
So, Mike, have the companies responded yet to the claim? What's happening there?
Yeah, so the companies have responded, and we are in the process of moving through the steps of the litigation. The next major milestone being the beginning of a case management process. So we look forward to just moving the case along as expeditiously as possible, keeping in mind what we think, this is a major societal issue, and so it deserves the eyes and attention of the court. And hopefully, we'll be able to share more news with you at a future date.
And Sonia, are there any comparisons you can draw to other countries? Has this been tried anywhere else?
So it's not, I wouldn't say it's an issue that's already been tried anywhere else. However, there are over 700 school districts in the United States who've commenced a very similar litigation, because of what we've talked about. This is a universal issue. It is impacting school climate. It's impacting the way that our kids learn. And, frankly, we need to do something about it. So yes, there is parallel litigation happening down south. Our laws are, Christine, as you know, very different than what's happening in the States. And so we have our own claims and our own unique way to sort of prove those allegations. And so that's something that does exist, but absolutely there are other people talking about this, and for good reason.
And Mike, this claim is exclusive to Ontario. Do you think there's potential to bring a claim like this in other provinces in Canada?
That's something that I don't know that I have the answer to today. I think to Sonia's point, certainly it's something that we see affecting all schools and all school boards across the country and across North America and beyond. So, that remains to be seen. We certainly encourage, again, to Sonia's point, everybody to take up this cause and to focus on finding solutions.
Mike, Sonia, really fascinating piece of litigation you have both brought. And I want to thank you for coming on today to talk about it.
Thank you.
Thank you, Christine.
We've heard today about a lawsuit against social media platforms for disrupting classroom learning. What do you think of the case and about the move by many provinces to now ban phones in classrooms? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.